Good evening, everyone. Should we start? Good evening, everyone. I hope everyone is keeping safe during these times of Corona lockdown. My name is Anuj, Handa advocate, and I am practicing primarily on the matrimonial side in Delhi. Today I'll be addressing a live session on cross-border matrimonial litigation and anti-suit injunctions. This being a legal issue, I will also be discussing the legal provisions applicable and the judgments rendered by various courts from time to time. But before we start, let me begin by thanking Team Desi Kanun for giving me this opportunity to interact with all of you. To understand the concept of this, the importance of this topic, let me first share some insight. As per a recent UN report, 17.5 million Indians are currently settled abroad. That is more than 1% of our population. Whether one goes to the US, Canada, Europe, Middle East, we are everywhere. Now, from the legal perspective, and more specifically from the family law perspective, this gives rise to its own set of challenges. Law everywhere is a reflection of society, and the law relating to family, marriage, divorce, child custody are a reflection of the current societal norms in that country at that time. Quite often one finds that when the relationship between an NRI couple gets strained, one spouse comes back to India and initiates litigation here, while the other spouse staying in the foreign country initiates litigation in that foreign court. This may happen in a number of scenarios. The first scenario may be where an Indian national living abroad marries a foreign citizen. The second scenario maybe where two Indian citizens living abroad meet in a foreign land and get married there. The third scenario may be two Indians while settled in India get married here but subsequently move overseas. And the fourth scenario may be, and this is something that comes very often, an NRI comes to India, gets married, returns to the foreign country. The spouse is yet to join him or her, but before the spouse can join him or her in the foreign country, differences arise and litigation is initiated in India as well as the foreign court. Now, in such a scenario, if parallel proceedings are allowed to be conducted in the foreign court as well as the Indian court, it would lead to absolute chaos and anarchy. The foreign court would take one view, the Indian court would take another view, and neither party would be able to enforce the judgments in their favor because of the conflicting judgments. It is for cases like these that the law provides the remedy of an anti-suit injunction, which is nothing but an injunction restraining the defendant from proceeding with legal remedies wrongfully invoked in another jurisdiction. Injunctions broadly are an equitable relief granted at the discretion of the court when the plaintiff can demonstrate that A, he or she has a good prima facie case on merits, B, the balance of convenience is in his or her favor, C, if the injunction is not granted, irreparable harm and injury would be caused to such plaintiff, and D, that the irreparable harm and injury cannot be compensated in terms of damages. Now, since an injunction is covered by sections 38 to 42 of the Specific Relief Act, one needs to look at section 41A and B, which are circumstances under which an injunction would normally not be granted. Section 41 provides that an injunction cannot be granted to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit in which injunction is sought, unless such restraint is necessary to prevent a multiplicity of proceedings. It also goes on to say the injunction cannot be granted to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. Now the question that I would put to myself is, then in case of an anti-suit injunction, essentially the relief being sought is to restrain a person from prosecuting a judicial proceeding, and even under 41B, that foreign court cannot be deemed to be a court subordinate to the court from which the injunction is sought. To understand this concept, we must understand that injunction being an equitable relief, the law has developed on the basis of various judgments passed by various high courts and the Supreme Court from time to time. And this issue of the applicability of 41A and B in anti-suit injunctions has been dealt with by the Honorable Bombay High Court in Sandeep Shankarlal Kedia versus Pooja Kedia, 2013, 4 Maharashtra Law Journal 673. I repeat, 2013, 4 Maharashtra Law Journal 673. In this case, while dealing with an anti-suit injunction, the Bombay High Court held that it is settled law that an injunction is a discretionary remedy. It is granted for the protection of the rights of parties in personam as also against their properties. Such injunction, this I would lay special emphasis on, such injunction cannot be granted specifically under the circumstances set out in section 41 of the Specific Relief Act, the first of which is to prevent parties from suing in other forums except when it would result in multiplicity of proceedings as to be counterproductive to both parties, entailing needless cost, expense and time. It is also established that courts would act in exercising their inherent powers in the interest of justice to grant injunctions. An anti-suit injunction would fall only under the inherent powers of the court and is consequently covered by precedent law. So the principle that can be culled out from this judgment is that while 41A and B might, technically speaking, bar an anti-suit injunction, but the law has developed by virtue of various judgments rendered from time to time. Now the question that arises is, what would be the circumstances under which an anti-suit injunction would normally be granted? What are the circumstances under which an anti-suit injunction would normally be declined? Various judgments have been passed on this issue from time to time, but the Supreme Court has authoritatively dealt with this issue in Modi Entertainment Network versus WSG Cricket Private Limited, 2003, 4 SCC 341. This judgment is the Bible insofar as the law of anti-suit injunction are concerned, and there can be no anti-suit injunction without referring to this judgment. In this judgment, the Honorable Supreme Court, while dealing with anti-suit injunction in a commercial dispute, has come out with certain broad guidelines. As per this judgment, any court seized of an anti-suit injunction matter has to examine whether the defendant is amenable to the personal jurisdiction of the court. Also, whether if injunction is declined, ends of justice will be defeated and injustice will be perpetuated. Another factor to be seen by the court while dealing with an anti-suit injunction is that is the principle of comity of courts and the court of greatest connection to the dispute at hand. Also, in a case where more than one courts in more than one country have jurisdiction to try the dispute, what is the forum of convenience to the parties? Which forum has the maximum connection with the rights and interests of the parties, their interstate obligations, and the dispute at hand? Now, dealing with these guidelines one by one, when would a defendant be deemed to be amenable to the jurisdiction of the court? The purpose of this requirement is that when a court grants an anti-suit injunction and the defendant violates such anti-suit injunction, certain consequences of law have to follow. Even under Order 39 Rule 2A CPC, which provides for consequences in case of breach of interim injunction, it is provided that if a defendant violates an interim injunction, his properties are liable to be attached and he is also liable to be committed to civil prison. Even in case of permanent injunctions, there are consequences of law that would always follow in case of a violation of an injunction order. So, in order for the injunction not to be an exercise in futility, it is necessary that the defendant is amenable to the personal jurisdiction of the court before which the anti-suit injunction action is brought. This issue, right since the very beginning, in fact, the Calcutta High Court in the year 1909 in Vulcan Iron Works versus Bishambar Prasad has held that when a defendant is not amenable to the personal jurisdiction of the court, no injunction can be granted. So the question that arises is, when is it that a defendant is deemed to be within the jurisdiction of the court? Is it that a person ordinarily living in India, when he travels abroad, ceases to be in the jurisdiction of the court? No. Any person who is domiciled in India, that would mean where he is physically present within the jurisdiction of the court, or where he is living in India but he has temporarily gone overseas, or somebody who is staying overseas in a temporary capacity but the intention is always to return to India, or when the defendant has properties in India or business interests in India, he would be deemed to be domiciled in India. The concept of domicile we will have to also see from the perspective of the judgment rendered by the Honorable Bombay High Court in Kashmira Kale versus Kishore Kumar Mohan Kale, 2010 4 Maharashtra Law Journal 395. I would repeat the citation, 2010 4 Maharashtra Law Journal 395. Apart therefrom also, if a defendant has sufficient connection with India, for example, in a case where there is an entity running a website which, though hosted outside India, the content is aimed at Indian audience, in that case the defendant would be deemed to have sufficient connection with India so as to be amenable to Indian jurisdiction. The next issue which is to be looked into by a court while deciding an anti-suit injunction is that if whether or not if the injunction is declined, the ends of justice will be defeated and injustice will be perpetuated. When would that be so? The first category in which if injunction is declined, ends of justice will be defeated and injustice will be perpetuated, it is cases where if the judgment of the foreign court is rendered, it would be hit by Section 13 CPC. Section 13 CPC deals with circumstances under which a foreign judgment is conclusive or inconclusive in India. It provides that a foreign judgment shall be conclusive as to any matter directly adjudicated upon between the same parties or between parties litigating under the same title, except when, this is also important, one needs to see that normally the judgment of a foreign court would be enforceable in India, except when it falls under any of the categories provided therein. The first category is where it has not been pronounced by a court of competent jurisdiction, or where it has not been given on the merits of the case, or where it appears on the face of the proceedings to be founded on an incorrect view of international law, or the refusal to recognize the law of India where the same is applicable. It would also arise in a case where the proceedings in the foreign court are opposed to the principles of natural justice, or where the judgment of the foreign court has been obtained by playing a fraud upon the foreign court, or where it sustains a claim founded on the breach of Indian law. This being the case, I will deal by each provision on Section 13 one by one in slightly greater detail. The first part of 13 where a foreign judgment would be deemed to be inoperable in India is 13A, which talks about the foreign judgment not being rendered by a court of competent jurisdiction. Now here one needs to also see that section 13A CPC is qualified by section 14, which provides that an Indian court on the receipt of the certified copy of a foreign judgment will always presume, unless the contrary appears on record, that such judgment was pronounced by a court of competent jurisdiction. So unless the plaintiff can demonstrate that the foreign court did not have jurisdiction to try this dispute, the case would not fall under section 13A CPC and the judgment would be enforceable in India. What now would be a court of competent jurisdiction to decide disputes between two Indians living abroad, an Indian and a foreigner, or two Indians, one living in India, one living abroad? The answer to this question has been given by the Honorable Supreme Court in Y. Narasimha Rao versus Y. Venkatalakshmi, 1991, 3 SCC 451. I repeat, 1991, 3 SCC 451. In this judgment, the Supreme Court, after examining the entire issue, holds that the foreign court will have jurisdiction if, as per the law under which the parties are married, such foreign court has been conferred jurisdiction and the grounds of relief are also provided under such law. So if parties are married under Indian law, what will need to be examined if, as per Indian law, the courts which have jurisdiction, the foreign court is also covered within that definition. For example, under the Hindu Marriage Act, territorial jurisdiction is provided in section 19. Now, section 19 says that every petition under this act shall be presented to the district court within whose ordinary civil jurisdiction either the marriage was solemnized, the respondent resides at the time of filing of the petition, the parties last resided together. In case the petitioner is the wife where she is residing at the time of filing the petition, or where the respondent is not residing within India or has not been heard of as alive for the past 7 years, where the petitioner resides. So if the parties were to be married as per the Hindu Marriage Act, the foreign court would have jurisdiction if and only if any of the categories mentioned in section 19 are met and the foreign court has been conferred jurisdiction. That is to say, if the respondent is residing within the jurisdiction of the foreign court, or the parties last resided together within the jurisdiction of the foreign court, or if the petitioner is a wife, she is living in that within the jurisdiction of that foreign court at the time of filing the petition. Here also, residence and domicile will need to be seen from the perspective of Kashmira Kale Mohan Kale, 2010 for Maharashtra Law Journal 395. Similarly, under the Guardians and Wards Act, jurisdiction is conferred on a court within whose jurisdiction the minor ordinarily resides. So if the minor child of the parties who are embroiled in the matrimonial litigation has been living in the jurisdiction of the foreign court would be a court of competent jurisdiction to try the issue of custody, guardianship and visitation of the minor child. Even if none of these categories is met, but the respondent being within the jurisdiction of the foreign court at that particular time submits to the jurisdiction of the foreign court, that is to say, appears before the foreign court, takes objections without taking an objection as to the jurisdiction of the foreign court, he or she is stopped from challenging the jurisdiction of that foreign court subsequently. And in such an event, if such party was to approach an Indian court seeking an anti-suit injunction, such injunction would usually be declined. Now the second category where a judgment of a foreign court would be hit by section 13 would be where it has not been given on the merits of a case. Suppose the foreign court was to decide a case on the basis of its own law, but its own law was such that the proceeding and the procedure are opposed to the principle of natural justice. In that event also, even if the foreign court has acted within the four corners of its own law, such proceedings being opposed to the principles of natural justice would always be hit by section 13b. But it is the criteria is that, my apologies, where it has not been given on the merits of a case. Suppose the foreign court dismisses the case in default, or by virtue of its procedure there is a requirement of seeking a leave to defend, and that leave to defend is either not sought or it is not granted, and judgment is automatically granted on the basis of the claim of the petitioner. In such an event, since the evidence of the case has not been discussed, it would be deemed to be a judgment not on the merits of the case, and it would be hit by section 13b. Similar would be a case where the foreign court dismisses either a case in default, or by virtue of the non-appearance of the respondent, a judgment is given in favor of the petitioner. But in a case where even if the respondent is not appearing, suppose the foreign court was to examine the evidence led by the petitioner and decide on the basis of that evidence, in that case the foreign judgment would not be hit by section 13, and such judgment would be enforceable in India. The next scenario where a foreign judgment would not be enforceable in India would be 13C, where a judgment is founded on an incorrect view of international law or the refusal to recognize the law of India. This would be when the foreign court grants relief on a ground which is not available under Indian law. As a matter of example, in India, Muslim personal law permits polygamy. But this may not be so everywhere across the world. There may be a lot of countries where polygamy may not only not be allowed, but it may also be a ground for divorce. Suppose an Indian Muslim man has two wives, one of whom files for a divorce on the ground of his having another wife living at the time of filing the petition. In such an event, on this basis, if the foreign court was to grant a divorce in favor of the wife, this judgment would be hit by section 13C, because this ground is not available under the law under which parties were married, which is the Indian law. Similarly, under the Hindu Marriage Act also, in order to sustain a petition for divorce on the ground of desertion, a petitioner must establish desertion for a period of 2 years. But in a foreign court in another country, the law may be that the petitioner needs to establish desertion for say 6 months or 1 year. In such an event, if a petitioner was to file for divorce on the ground of desertion, on the basis that for the previous 6 months the husband or wife has deserted him, and judgment was granted on this basis, such judgment would be hit by section 13C, since it has been given on a ground not available under the law under which parties were married. The next category where under section 13 a judgment would not be enforceable in India are where the proceedings are opposed to the principles of natural justice. Now, although the principles of natural justice are self-explanatory, but if the procedure of the foreign court, even if in accordance with the law of that foreign court, is such that the principles of natural justice are violated, such judgment would be hit by section 13D and not be enforceable in India. But here, just that the fact that the judgment is wrong in law will not suffice. There will have to be something more to show that there is inherent bias or unfairness in the procedure involved. These would be cases where, for example, the judgment can be given without notice to the respondent, even if it is law, even if it is the law before that foreign court. If the judgment is given without notice to the respondent, this would be deemed to be a violation of principles of natural justice, and such judgment would be hit by Section 13. Or where there is a judgment against a minor and the minor is not represented in the legal proceedings by a legal guardian, or where notice has been issued to the respondent but neither legal representation is allowed nor the proceedings take place in a language known to the respondent. In such an event also, since the respondent is not in a position to follow the proceedings in the court, the procedure itself would be opposed to the principles of natural justice, and such judgment would also be hit by Section 13. The last category in this would be where the court itself can be shown to be inherently biased or partial in favor of a party. In that event also, the judgment would be hit by Section 13, being opposed to the principles of natural justice. The fifth category in Section 13 is where a judgment has been obtained by a party from a foreign court by playing a fraud upon that foreign court. For example, suppose A and B are married in India. Over a period of time, the relationship between the parties gets strained and the parties separate. In the meanwhile, one of the spouses travels to another country for say 2 years, and during his stay in such foreign country, he files a petition for divorce on the ground that I have been living in this within this jurisdiction for the past more than 1 year. My husband or my wife has deserted me, and therefore I am entitled to a divorce. This judgment, if rendered in favor of the petitioner, would always be hit by Section 13E because it has been obtained by playing a fraud upon the court. The last category in Section 13 where the judgment would not be enforceable in India is where the foreign court passes a judgment on by sustaining a claim founded on the breach of an Indian law. Suppose an Indian court was to grant custody of children to a mother, but the father, instead of complying with that order, travels to another country and files a petition for the custody of the children in that country. Now, since this claim is founded on the breach of the order of the Indian court, this would be hit by Section 13F, and such judgment, if rendered, would not be enforceable in India. Even apart from cases where Section 13 is involved, there may be scenarios where the judgment, though enforceable in India, but the circumstances are such that the plaintiff is able to demonstrate that if injunction is not granted, there would be a miscarriage of justice, the ends of justice would be defeated and injustice would be perpetuated. In such cases, injunction being a discretionary relief, the court can always exercise its powers and grant an anti-suit injunction. There can be a number of scenarios in which this can happen. The first scenario where this can happen is where, although the foreign court is a court of concurrent jurisdiction with Indian courts, but the forum convenience, that is to say the court having the maximum connection to the rights of the parties, the welfare of the parties, the inter obligations of the parties, and the dispute at hand, are the courts in India. In such an event, Indian courts can always grant an anti-suit injunction restraining the defendant from proceeding with the legal remedies in such foreign court. A number of judgments have been rendered in this regard. One interesting judgment would be Harmita Singh versus Rajat Taneja 102 2003 DLT 822. I repeat the citation: 102 2003 DLT 822. In this case, the parties had been married in India on the 24th of March 2002 and they leave for the United States on the 27th of March 2002. On 27th August 2002, certain differences arise between the parties, and she is compelled to leave the matrimonial home and come to India. In the meanwhile, the husband files a divorce petition in US, but the wife can also not return to the US now to contest the case because she does not have a valid visa to travel to the US again. In this case, after going through the entire factual circumstances of the case, the Delhi High Court held that the stay of the wife in the US can be deemed to be transient and temporary, and hence she was entitled to an anti-suit injunction. But what about cases in which the parties, even though they may have been married in India, have been staying abroad for the past, say, 6 years, 7 years, 10 years? In this case, since it is the courts it is the foreign courts which have the greatest connection with the dispute at hand, an anti-suit injunction would normally be declined. Similar thing happened in the case of Dinesh Singh Thakur versus Sonal Thakur, which is civil appeal number 3878 of 2018 in the Honorable Supreme Court, where it was held that the parties had been living in USA since 1995 and had even obtained a US citizenship in 2003. Disputes between the parties having arisen in 2006, the ends of justice cannot be said to be defeated if injunction is not granted. In fact, the Supreme Court in Surinder Kaur Sandhu versus Harbakh Singh Sandhu goes a step further to say that ordinarily jurisdiction must follow functional lines. That is to say, for example, that in matters relating to matrimony and custody, the law of that place must govern which has the closest contact with the well-being of the spouses and the welfare of the offsprings of marriage. The spouses in this case made England their home where this boy was born to them. The father cannot deprive the English court of its jurisdiction to decide upon his custody by removing him to India, not in the normal movement of matrimonial home, but by an act which was gravely detrimental to the peace of that home. The fact that the matrimonial home of the spouses was in England establishes sufficient contact or ties with that state in order to make it reasonable and just for the courts of that state to assume jurisdiction to enforce obligations which were incurred therein by spouses. Apart from this also, there may be a number of other scenarios in which the courts in India may be inclined to grant anti-suit injunctions in favor of the party approaching it. For example, one may be a case where the spouse living in India does not have the financial resources to travel to the foreign country to live there and to contest the case before the foreign court. Another case may be where the nature of the profession of the spouse living in India is such that if he or she was to travel to that foreign country, it would not be possible to secure employment sufficient to live there and contest the case in such foreign court. Or even in a case where even if legal representation is allowed, but proceedings would take place in a language alien to the party present in India, even in that case the courts would normally grant an anti-suit injunction. Here in this instance one also needs to understand that it is not just that the proceedings have to take place in another language. As long as the spouse present in India understands that language, this clause would not be attracted. It is only when the proceedings are taking place in a language not known to the spouse present in India. Enough of optimism. While dealing with a case of anti-suit injunction, what will also be seen is the concept of comity of course. That is to say, no court would normally interfere with the exercise of jurisdiction by a foreign court. It would only be in exceptional circumstances where the plaintiff can demonstrate that if injunction is not granted, he or she will suffer irreparable harm and injury, that an anti-suit injunction is going to be granted. Even in the most authoritative judgment on this aspect, which is the Supreme Court in Modi Entertainment, it has categorically found that the remedy of anti-suit injunction is to be granted only sparingly. The burden of establishing a case for anti-suit injunction is on the plaintiff at all times, and it can be done only when the plaintiff establishes that in case anti-suit injunction is not granted, ends of justice will be defeated and injustice will be perpetuated. So in conclusion, the principles of an anti-suit injunction can be summarized like this. For an anti-suit injunction to be granted, first of all, the defendant needs to be within the jurisdiction of the Indian court. Secondly, it will need to be seen whether the judgment of the foreign court would, if rendered, would be enforceable in India as per section 13 CPC. It would also need to be seen whether or not the proceedings in the foreign court can be deemed to be vexatious or oppressive, or where although the foreign courts are courts of competent jurisdiction, whether the foreign court is the forum convenience or it is the courts in India which is forum convenience, or where the continuation of proceedings in the foreign court will cause irreparable harm and injury to the plaintiff. In such events, anti-suit injunction can be granted. Although I again add a caveat that this will be the first thing that will be seen is the concept of comity of courts. With this, my session on cross-border matrimonial litigations and anti-suit injunction comes to an end. If anybody has any questions, I will be more than happy to answer. So I think if nobody has any questions, I think we'll put an end to this session. Thank you all, and once again thank you Team Desi Kanun for giving me the opportunity to interact with all of you.